And what was seared in my memory was going to a detention facility in Berks County, Pennsylvania. And I remember distinctly watching Black and brown men being brought into the immigration court, which was housed within the detention facility. They were shackled, they had orange jumpsuits on. This image of Black and brown men, coming in shackled in orange jumpsuits looked very familiar to me.
Hey, yo, boss, that's a banger.
What does it mean to be a nation of immigrants? The question of who gets to come here and who gets to belong here has always been deeply fraught. The question of immigration has become the defining issue of Donald Trump's rise and return to power. From his early rise within the birtherist movement, questioning whether Barack Obama was eligible to be the U.S. president, to his current administration's stunning attack on birthright citizenship, which was narrowly overturned by the Supreme Court. President Trump has moved with unprecedented power to reshape the American political system. Now, we are seeing dramatically the tragic consequences of that expansion. This week, July 20th, we're mourning the killings at the hands of ICE officers of Lorenzo Salgado Araujo and Juan Sebastian Guerrero. We are also thinking of Alex Preddy and Renee Good, two American citizens who were murdered by ICE in the winter. Today's guest will help us to understand why it is deeper than a political question of the moment. Deciding who belongs in America is actually a question that goes back to the very first naturalization laws passed shortly after this nation's founding. As we continue to figure out who deserves to belong in America and what role the courts play in enforcing inclusion and human rights, I'm very pleased that this week we are joined by Karla McKanders. She's an expert who spent more than a decade writing at the intersection of race and citizenship, and she has wonderful insights to help us navigate not only this moment, but who we want to be as a nation going forward. We're joined by Karla McKanders, an expert in critical race theory and immigration law, who directs the Thurgood Marshall Institute at the NAACP Legal Defense Fund.
Thank you for having me today.
Well, we're very, very pleased to have you. As I'm sure you're aware and our listeners will be aware, there's been a lot of new attention on the abuses in our immigration system, especially with the rise in ICE raids and the killings of Renee Good and Alex Preddy. But you've actually been writing about these issues for more than 15 years. So we're really excited to get a deeper look at the more structural issues than sort of the crises that we're seeing today. But before we dive into what we're seeing, I wanted to know what drew your interest to this area and what made you want to dive into the scholarship around immigration law.
Well, my interest started probably when I was younger. I wanted to be a civil rights attorney, and I pursued that through college, going to law school, but specifically when I was studying abroad in Strasbourg, France, in undergrad, I ended up working at a refugee center. So I was working with refugee children from Afghanistan, from Kashmir, and seeing how they were integrating into life in France. And often when you are abroad, you begin to make connections between what you experience or live in your country and what you're seeing abroad. And what I noticed when I was interning, just little things, residential segregation of immigrant communities, the ways in which immigrant communities in France experience discrimination. And that put me on kind of a track of just thinking about immigrants and racial discrimination and integration into community. I went off to law school and ended up going to work for a law firm, like most people do when they graduate from law school. And then I clerked for Judge Damon Keith on the Sixth Circuit Court of Appeals. And at the time, there were a backlog of immigration cases coming up to the Sixth Circuit from the Board of Immigration Appeals. And I was the law clerk in the office that would handle all of the immigration appeals and, write bench briefs for Judge Keith. And in talking to some of his former clerks, I decided that I would pursue a clinical teaching position. And what happened was I ended up going to Villanova Law School and teaching as a fellow in the asylum clinic there. And Again, I was working with immigrants who were in detention facilities, probably about 2 or 3 hours outside of Philadelphia. And what was seared in my memory was going to a detention facility in Berks County, Pennsylvania. And I remember distinctly watching Black and brown men being brought into the immigration court, which was housed within the detention facility. They were shackled, they had orange jumpsuits on, and they were taking what is called voluntary departure. It's where you decide to forego your immigration hearing. No counsel was present, and in mass, they were bringing in 20 men at a time, and they were, taking voluntary departure. And it invoked this image of Black and brown men, coming in shackled in orange jumpsuits, looked very familiar to me. And that started me exploring what are the ways in which our criminal systems treat Black and brown men? How is their behavior criminalized? And I started this exploration in my scholarship looking at, the foundations of immigration law in our country, the foundations of policing Black people in the United States. And that kind of set me on this trajectory back in early, 2000s, making the historical connections. All of the connections aren't parallel, but they are very similar in ways.
I'm interested in the parallels that you found, because you said you traced back the historic record. One claim that I've seen you make is that race is baked into the very foundations of our immigration system. Can you say a little bit more about how you came to believe that and what the evidence is there?
When you look at the foundations of our country and you go back to the 1790 naturalization law, that was the first law that allowed individuals to become citizens of the United States. And you could only naturalize in the United States if you were a free white male. Actually, the language of the statute said that you had to be a free white person, but women were not allowed to own land. So in practice, it was only free white men who could apply for and become U.S. citizens. And that set the tone for membership and belonging in the United States and what it meant to be a citizen in the U.S. 1790, along with the Dred Scott case from the Supreme Court, another foundation in terms of who we think of as a citizen. And in the Dred Scott case, we certainly saw Dred Scott, who was in the North, saying that I'm in the North, applying to the courts to obtain citizenship. And the famous line by Justice Taney was that the Black man has no rights to which the white man is bound to respect. And those are some of the core foundational laws that establish what does it mean to belong in the United States and who is entitled to rights in the United States that are afforded to people that are citizens. And so with that foundation, I think we go on to Reconstruction, and we see the 13th, 14th, and 15th Amendments giving Black people the right to be citizens, the right to vote in the United States. And that kind of opens the door for a more multiracial democracy. But with immigration laws, even after the Reconstruction Amendments, you had Congress passing a new naturalization law that included Black people. And one of the things that I always teach in my immigration class, in my critical race theory class, are the prerequisite naturalization cases. After Reconstruction, you had individuals who were from outside of the United States applying for citizenship. And their arguments that they weren't making the argument that I am Black and therefore I should be considered a citizen. And you see in those cases, the judges, Supreme Court judges, federal judges, defining, socially constructing race. They're saying what whiteness is, not relying on scientific evidence, which shows that there's little difference between, who is white and who is Black, but relying on the common understanding of people at the time to determine who is white and who is not white and who should be able to belong in the United States, who should be able to naturalize in the United States. This is baked into the foundation of our country and how we conceptualize race in America.
It seems like you're saying in the first Naturalization Act, they had literally put that you had to be white to become naturalized to the U.S. You're just saying there was not any non-white immigration to become actual citizens from there until the Civil War. Is that right?
Yeah, and so 1790, the Naturalization Act said you had to be a free white person. So that was, written into the law. So if you came to the United States, the only way that you could apply to be a citizen was if you were white, you owned property, and you were a male, and all other persons were excluded. And this is why the 14th Amendment is so critical, because the 14th Amendment gave Black people citizenship. The citizenship clause says all persons born or naturalized in the United States are U.S. citizens. And we see that the 14th Amendment is really foundational in terms of opening up the door for the beginning of a multiracial democracy.
And yet it seems like this problem of an idea of racial barriers still persisted after the 14th Amendment is passed, which in some way you would think, well, shouldn't that get rid of the idea of that there's going to be racial classifications in our naturalization law? How did that persist? Like, were people debating it?
That is where you get to those prerequisite cases. And those are the cases where, right after the 14th Amendment was ratified, you had Congress debating about what should the naturalization clause look like and who should be able to naturalize, who should be able to apply for citizenship if you're not born here. And what happens is you see in some of the legislative history, congressmen are going back and forth and they're saying, should we include Chinese nationals? Should they be able to apply to become U.S. citizens? And so you see this, intense debate about race and belonging. And so even after the 14th Amendment was ratified, you had the political branches and the courts through these prerequisite cases defining, constructing race. So we don't have formerly enslaved people being excluded, but you see the law kind of shape-shifting and constructing race in other ways that continues the exclusion of people who are not white in the United States.
The language of the 14th Amendment, at least, is pretty clear about the use and consideration of race. How did they justify that this should not apply in some cases in the immigration context?
And so what you get to when we're talking about immigration, there are naturalization laws, which determine who can become a citizen. And then you have immigration laws, which govern who can enter, who can exit, who can stay in the country. And when you look at immigration law, there's a doctrine, it's called immigration exceptionalism. And this doctrine goes back to the Chinese Exclusion Acts, where Congress passed laws, and in those laws during the 1800s, they said that Chinese nationals could not come to the United States and they could not receive immigration status, put very simply. That is one of the country's first travel bans. And then, those cases went to the Supreme Court, and the Supreme Court established this doctrine where when the political branches are enacting immigration laws, Congress, or enforcing immigration laws, when you have the invocation of national security or foreign affairs, the courts are going to be very deferential to the political branch's decisions. And what that has created, it has created a space where when you have immigration laws, when you have the president saying that they are regulating foreign affairs, the courts will not apply constitutional norms to immigration laws. And so if we go to Trump versus Hawaii, where you had the first travel ban by the Trump administration, what you see there is you see Justice Sotomayor's dissent saying that we can't invoke national security and foreign affairs and not pay attention to the intent behind the laws. And we know that first iteration of the travel ban turned into disproportionately impacting individuals, immigrants from African and Muslim majority countries, and it became known as the African Muslim ban. We see this long trajectory from 1790 to Dred Scott to the Reconstruction Amendments, and then we go to the Chinese Exclusion Act, and we see that immigration has carved out this space for exceptionalism where constitutional norms are absent.
So the courts are part of the story of coming in, developing this doctrine of we're not going to look too closely at what's actually going on underneath the surface with immigrants. People can get into a navel-gazing mood, and I think the nation seems to be in that mood where it's like, well, that's happening to immigrants, but it doesn't really have anything to do with citizens, right? Well, too bad for them, but they're not in this country. What are the stakes for citizens of having this exceptionalism applied to non-citizens?
One foundation of our multiracial democracy is that we honor the humanity and dignity of all persons. And we see the language, all persons are entitled to in the Reconstruction Amendments. And, you mentioned at the beginning of this podcast protests that went on in Minnesota. And we see that whether there is an immigrant family that is mixed status, meaning one parent might be a U.S. citizen, another parent might be undocumented, the children might be U.S. citizens, there is an impact on all persons, the policies that come out of the Department of Homeland Security and the enforcement of our immigration laws. And that wide discretion has allowed racial profiling of different communities. The Thurgood Marshall Institute just put out a mini report looking at the various cities in which DHS in Chicago and Minneapolis and Nashville was going into. And they did a neighborhood by neighborhood analysis of which communities were targeted. And in that analysis, you see that the majority of the communities, not just immigrant communities, but the communities that were targeted were disproportionately Black and Latino communities. And so we know that immigrants are the canary in the coal mine. You can't tell someone's immigration status from just looking at them. You can't tell someone's immigration status from listening to them talk. Profiling doesn't work. Immigration law is very complicated. The Immigration and Nationality Act is second to the tax code in terms of its complexity. So if we are applying immigration laws accurately, we know that you can't determine whether someone's lawfully in the country based upon pulling them over. And so giving the Department of Homeland Security this wide discretion violates human rights norms, civil rights norms, and it's not aligned with honoring the humanity and dignity of all persons in our country.
Basically, people had at least described it as the green light from the Supreme Court to consider race in conducting these stops, which does seem to open the doors to, well, you'll be whoever you are, but if you're in a Black or brown community, simply by that status, by the fact of having certain jobs, you're opened up to this kind of repression.
Exactly. I think we need to be mindful when we think about the rights of people that we're not using that exclusionary standard that comes from our foundations of 1790, but we're thinking broadly about the humanity of all persons who are within our country.
You've also written about how the immigration system is being used to undermine democracy and how different statuses have been weaponized to suppress dissent. Would be very interested to hear you talk a little bit more about that and how that's playing out now.
Again, it goes back to that doctrine of immigration exceptionalism. Throughout our country's history, the immigration laws have been used to shield people from exercising their First Amendment rights. And recently we saw that when we had different universities where student visa status were threatened to be revoked based upon the speech that was going on campuses and the protests that were occurring on campuses. And the latest article that I wrote, I kind of traced this all the way back in our nation's history from the Red Scare. That was some of the first times in our country's history where we saw the regulation of immigration or deportation against individuals who were dissenting against the United States. We also saw that around 9/11, where we had individuals who were of Muslim descent who were protesting against the United States, against our country. Different administrations tried to deport individuals based upon the speech that they were exercising. The key point here is that history plays a large role in terms of understanding where we are today. There's usually nothing new under the sun When we look at what's going on today, those tactics have started. What we see today in immigration spaces is a long trajectory from the Chinese Exclusion Act to present day in terms of creating this space where the executive branch has wide discretion to regulate immigration. And you can't understand what's happening today with ICE unless you go all the way back to the Chinese Exclusion Act and you look at the acts that excluded Chinese nationals and how that shaped the ways in which immigrants are excluded from constitutional protections.
So many things in our life just seem inevitable. So because we have the precedents now for, it seems like at least 100 years, if we go back to the Red Scare, of the government doing this and courts not intervening, it almost seems hard to imagine it being different. Would there be real possibility for the court to intervene in another way? What have you seen in terms of alternatives of ways that this could be different?
The Reconstruction Amendments are an example of that arc that bends towards justice. So after the Reconstruction Amendments, we see that there's a possibility. There's a possibility of giving Black people, allowing them to vote, allowing people who are born in the United States to obtain citizenship, obtain membership and belonging. So there's an arc. Our country ebbs and flows in terms of bending towards justice. The work that I do at LDF, there are days that are difficult, but then I look back at, the work of Thurgood Marshall and the work of Constance Baker Motley, and the times that they were litigating in were similar, even worse at times. We have that kind of blueprint in terms of working towards justice. And at LDF, we say we work from in the church basements to the halls of justice. And that is, what we're doing. I think we should learn from the lessons of people that came before us. The Thurgood Marshall Institute wrote a brief on the colored conventions movement. And it was a movement of freed and formerly enslaved individuals, what they wanted pre-Reconstruction for our country to look like and the rights that they wanted Black people to have. We had the civil rights movement in the 1960s where lawyers, organizers, churches had a vision of what our multiracial democracy would be like. And we're in a dark period where voting rights are being rolled back. But there's also, continuing to push for change and continuing to hold the light of our multiracial democracy. We have judges who are dissenting. We have lawyers who are there that are continuously writing briefs. And we're doing research at the Thurgood Marshall Institute, continuously pushing for the world that we want and the country that we want and this vision of a multiracial democracy.
You've written about Justice Sotomayor and what she is accomplishing and doing through her dissents, even if they're not controlling. I'd be curious if you could talk a little bit about that and what does it mean to dissent now? What is the power and value in that?
In the piece that I wrote about Justice Sotomayor's dissent, I examine, the power of dissenting. And I specifically look at the travel ban case, the Trump versus Hawaii case. And you look at her pushing back against this doctrine of immigration exceptionalism and saying, no, we must look at what is the animus, what is motivating the travel ban, and giving us historical memory, too, within her decision, her dissent in Trump versus Hawaii, letting us know that the darkest times in our country were with Korematsu and, being overly deferential to the executive branch. And so that piece highlights that there is an importance in continuing to dissent and continuing to lay the foundation or the blueprint for what we want our multiracial democracy to look like.
You've written about and saw parallels increasingly in commentary about the connection between the Fugitive Slave Act and the era of slave catchers and what we are seeing on our streets with ICE and these attempts to catch folks. Very fascinating. I was wondering if you could talk a little bit about the parallels that you see there.
When I was early 2000s as a young scholar, looking at and going back to that image of the Berks County detention facility in the courtroom, I began to look at the Fugitive Slave Act and look at the system of removal that was put in place to remove enslaved people back to the South. eerily, they had what were called certificates of removal. Those certificates of removal would be issued, and individuals would be, profiled and brought back to the South and enslaved. The systems don't line up exactly, but when we think about how policing occurs in our country, how the policing of Black bodies occurs, the Fugitive Slave Act is a core component of the ways in which we see Black bodies and the ways in which we criminalize Black bodies, and how that system allowed for individuals who were common citizens to say, hey, that person is an enslaved person, and to, exercise, they were deputized to bring people back to the South. And we see some policies like that with our 287G programs, where immigration is a federal system, but 287G allows local and state law enforcement to be deputized and racially profile and say that person looks like they are undocumented or they're in the country unlawfully, and hand them over to Immigration and Customs Enforcement, ICE. That piece that I wrote in the early 2000s really kind of just examines parallels in terms of what administrative system existed, how were these, certificates of removal and what we call deportation orders, how were they executed, and what are the parallels between the two. Again, we go back to this core principle of understanding what our nation's history is so that we can understand what's going on today. It's a core component of understanding how forced migration works in our country. It, really underscores this principle of how the normalcy of racism pervades many facets of our deportation system, our criminal legal system, how the criminal legal system creates a pipeline, a prison to deportation pipeline for Black and Brown people in the United States.
One thing that stuck out to me about what you said just now is normalcy, because I think it is quite interesting, and folks have rightly pointed out in this moment that there has been this ebb and flow of movements around immigration justice, right? You started writing your things far before the current administration. You're writing it in the Biden administration, the Obama administration. There can be sometimes the sense of normalcy of practices that are still going on, right? I think it's provocative and sometimes difficult to think about, like, okay, what are the things that we are normalizing and think are okay that are happening in our society just because it seems to be a more calm or routine way. In the fugitive slave era, I think it's interesting because you have people who are, you can either be cooperative, neutral, or resistant, right? There are people who were actively trying to get the reward and being like, hey, I know where somebody is. There are people who are like, this has nothing to do with me. And there are people who are actively like fighting slave catchers, hosting people in their houses. So it is just very provocative when you bring that question of normalcy, because like, what are the things that we also are accepting in our day-to-day?
Exactly. And what are the things that we might not pay attention to historically that lead us here today? And this is why the history, examining history, making sure that history is accurate is really important, so that we can learn the lessons from way back to the 1790 Act to present day and understand how we got here. Because I think understanding is the way to try to combat some of these laws and to really push forward. I think we're on the precipice of having a multiracial democracy, and that's why we're seeing so much pushback. History plays a large role in realizing that vision of a multiracial democracy in the United States.
I also want to talk a little bit about the civil rights movement and the parallels you see there. It is interesting that eventually these requirements about being white or having a certain racial background do seem to fall off the same time we have the civil rights movement. And you've also written about parallels you see with Jim Crow and now. So just curious if you could talk a little about that.
Around 2008, we saw states and localities starting to become involved in the enforcement of immigration laws. And specifically, you had states and localities passing immigration laws. Again, in Pennsylvania, there was a town called Hazleton, Pennsylvania, and they were one of the first cities to pass laws that said if you rented to someone who was undocumented, that you would get your business license taken away, that had English only provisions. And those laws in Hazleton were the goal was to make it life so difficult for immigrants that they would want to move out of Hazleton. And you saw that those laws start to be passed in different jurisdictions across the United States. And Arizona was another state that picked up on these laws and passed the law, I believe was SB 1070. And what they did was they deputized their state and local law enforcement to enforce immigration laws. And that case went all the way up to the Supreme Court, examining issues of where are the places where states and localities can regulate immigration. And so when we look at the civil rights era, we see that same tension between state and local laws that were intended to exclude individuals from life in communities, were intended to, have sundown towns where Black people were not allowed to be in a town after a certain hour. And you see the parallels in terms of Jim Crow laws and those laws that were being passed around 2008. And you see that kind of proliferating until we get to today, where you have, the 287G agreements, and you have states and localities who, Florida, for example, at the beginning of this iteration of the Trump administration, I believe it was every county in Florida had a 287G agreement, which meant that law enforcement were able to pull over someone. They could detain them and put what's called an ICE hold on an individual and, cooperate with immigration and customs enforcement. Again, I think you have to really understand history, the way that laws are kind of reiterating themselves, what tactics are similar, what things are different, in order to come up with strategies to combat these discriminatory laws.
It's actually surprising to me that 2008, because 2008 is relatively recent for some of us, that this is a legal structure that actually folks hadn't had and that is being established now. What do you make of or see as the impetus behind the rise of these new forms of discrimination and or harassment of immigrants?
One thing that is often missed during the civil rights movement, racial quotas were eliminated from our immigration laws. So there were quotas in terms of which countries could have unlimited migration to the United States. And our immigration laws privileged individuals who are from Western countries. During the civil rights movement, those quotas were removed. Our immigration system didn't require you to come from a certain place to immigrate here. And I think if we go from the civil rights movement to present day, we're seeing some of the impact of removal of those quotas. And we see that the law, again, is pushing towards equality. It's allowing us to move closer to our multiracial democracy. These different points within our history allow us to kind of live into a vision where people are equal, where people have, their civil rights. And now we're experiencing a backlash to the progress that has been made in generations from the past.
If I was putting it bluntly, when immigrants were all white, it wasn't a problem. It wasn't, seen as this same problem for the law. And then when you get rid of the quotas and you have a new profile of immigrants, it's bringing new anxieties, bringing new needs for control that maybe weren't there when, as the 80s, 90s, and the doors seemed open, at least for some.
Definitely.
You've learned a lot about a lot of just terrible things that have been done to people at different points in history. What lessons do you take on how people resist unjust systems effectively, and what do you think is useful from those?
I strongly believe that the community organizing, that is the heart of where change occurs, that it's people in their church basements gathering. I think Minnesota is a great example where people in their neighborhoods were saying, no, we're not going to allow ICE to be here. That is where change comes from. And I would often tell my law students that as lawyers, we're just here to kind of push the law across the finish line to make sure that it is aligned with what we are seeing directly on the ground in our communities.
You have a very deep and continued clinical experience, as well as your academic research. Are there ways that your research and knowledge have made you show up differently in terms of practice?
At the center of all of the work that I've done, over the course of my career is the person, the community, the humanity of people, walking alongside people as they try to obtain their rights. In Tennessee, me and my students represented asylum seekers and unaccompanied minor children. I view the work that I did there and the work in conjunction with my students as, using the law to give people voice. People who in Tennessee had to drive 6 hours to get to immigration court, and they often did not have a car, didn't have resources to hire an attorney, let alone get across the state to Memphis to go to immigration court. And so over the course of my career, I just, despite the dark times that we're in, believe that lawyers play a critical role in honoring the humanity and uplifting the humanity of the clients that they represent, and being in partnership with the community, being there to listen and understand what's going on and, translate that into arguments that are made before the courts.
Thank you so much. Really appreciated you having the time to join us on this podcast.
No problem at all. Thank you for having me. This has been a great conversation.
Reconstructed is a project of Douglas Collective, a 501c3 organization working to abolish injustice and advance the common good. If you enjoyed this episode, you can support our work by leaving us a review, sharing the episode on social media, or going to douglascollective.org/donate.